Hello, my name is Muhammad Saad Habib. My student ID number is 241111936 and this is my student ID card. So let's start with the presentation. The presentation is about giving legal advice to Hareem's situation and assess her legal rights and remedies under the Sale of Good Act 1979 following her commercial dealing with Rivaj UK and bespoke bridal jewelry retailer based in London. We will begin with a summary of key facts, identify the legal issues arising, apply relevant statutory provision, refer to important case law, and then conclude with clear legal advice and suggested remedies. Let's begin with the facts. Hareem is a jewelry reseller who operates her own business, Hareem Jewels, in Hatfield. In anticipation of an upcoming fashion show, she visited Rivaj UK and placed three separate orders. First, she ordered a bespoke necklace set, an antique gold and champagne crystal necklace with matching jhumka earring. It was crucial that the entire set be hypoallergenic, specifically made from titanium, as her model were allergic to other materials. Sana, the store manager, confirmed that it would be. Secondly, Hareem purchased five discounted rings, which were advertised as being sold at 50% off due to missing gems. Lastly, Hareem asked for 10 blue and 10 maroon choker sets to match her model's outfit, and Sana agreed to a discounted price of £20 per set with a delivery deadline of 20th May. When the item arrives on 20th May, several problems emerged. The necklace was not hypoallergenic. When worn by a model, it caused a visible rash. Three of the five rings had missing gems, and instead of the agreed quantities, the chokers include only four blue, eight maroon, and six green set, while greens having were never been discussed. When Harim contacted Sana to return the goods, she was told that the Rewaj UK does not offer refunds or exchange as per store policy. This brings us to the legal issues. Four key questions arises. First, was the necklace fit for the purpose clearly communicated by Harim? Second, were the rings of satisfactory quality? Third, did the choker set match the agreed description and quantity? And fourth, can Rivaj UK lawfully rely on store policy to refuse refund? The relevant legal framework is primarily found in the Sale of Good Act 1979. Section 13 requires goods to correspond with the description. Section 14.2 implies a term that good must be of satisfactory quality, taking into account the price and any defect made known to the buyer. Section 14.3 states that where the buyer makes known a specific purpose, the good must be reasonably fit for that purpose. Section 15 applies where goods are sold by sample and state the bulk must correspond with the sample. Section 27 concerns delivery of goods and requires the seller to deliver the agreed quantity. Finally, under Section 55, consumer rights cannot be excluded by contractual terms in consumer contracts. Coming to the necklace situation, Harim clearly communicated the intended purpose. It had to be hypoallergenic and made from titanium. Sana explicitly reassured that this would be the case. Under Section 14.3, a term is implied that the goods will be fit for the purpose which constitute a condition. Since the necklace caused a severe allergic reaction, it failed to meet that standard. This amounted to a breach of contract, giving Harim the right to reject the item, repudiate the contract, and seek damages. This interpretation is supported by key case law in Grand versus Australian Knitting Mills 1936. The buyer suffered dermatitis from woolen underwear and the court held the seller liable as the good were not fit for the purpose. Similarly, in Balmoral Group versus Borealis UK Limited, the buyer had specified the required use of product and the goods provided failed that use. This precedent confirmed that Harim has a valid legal basis to reject the necklace. Now, Let's address the rings issues. While Harim was informed that the rings were discounted due to missing gems, the expectation is still that they must be of satisfactory quality under Section 14 subject to no defect, which also constitute a condition. Since the defect were disclosed, this may not constitute a breach. However, if the rings were chosen from a sample tray and the delivered item were in a worse condition, then section 15 becomes applicable. Under section 15, where a sale is by sample, there is an implied term that the bulk will match the sample in quality, which is condition. If it was not the case, Harim can claim breach, giving Harim the right to reject the item, repudiate the contract, and seek damages. Relevant case law here is Goldie versus Perry, where a toy purchased by sample injured a child. The sample had been saved, but the bulk was defective. The seller was held liable for failing to meet the standard set by the sample. In contrast, the case of Lemar versus L&A International Limited, the courts held that the disclosed defects may protect a seller, but only where those defects match what was shown in the sample. So, if Harim rings were worse than expected, then she may still have a claim under Section 15. For the choker sets, there is a clear breach under Section 13 and 27. Section 13 requires that good must match the description, which is a condition, and Section 27 requires delivery of the agreed quantity. Rivaj UK delivered 4 blue, 8 maroon, and 6 green set instead of 10 of each blue and maroon. The green sets were not agreed upon and are not substitutes. This is only a shortfall in the quantity but also a deviation from the agreed products in the description. This situation is supported by case law such as Arcos Limited versus Ronesen and Son, where a timber was slightly too thick was still held to be non-conforming. In Remoor versus Remoor and Co versus Landover, a delivery of correctly labeled fruit in the wrong packing was held to be a breach. These cases reinforce the idea that precise compliance with the term of description and quantity is mandatory. Lastly, on the matter of Rivaj UK refund policy, the store claims it does not offer refund or exchange. However, under Section 55 of the Sale of Good Act, this is void in consumer contracts. Buyer cannot be deprived of statutory rights. Statutory right always prevail. If Harim made the purchases as a consumer, this clause is entirely invalid. If she purchased them for her business, then the clause would be assessed for fairness under the unfair contract term 1977. Either way, her statutory remedies cannot be overridden by the store policy. In summary, to conclude, my advice to Harim is as that the necklace can be lawfully rejected due to its failure to meet the specific requirement of being hypoallergenic under Section 14.3. The choker sets clearly breached Section 13.27 and should be returned or replaced. The rings may be more nuanced if they were worse than the sample. There is a potential claim under Section 15. Finally, the refund policy is likely invalid and Rivaj UK cannot legally refuse to engage with Harim claims. For the remedies, Harim is entitled to reject the defective goods and demand a refund under Section 15B and 48 of the Sale of the Good Act. She may also demand the correct choker sets or terminate the part of the contract. Additionally, she can claim damages for losses suffered, such as reputational harm or disruption to the fashion show. Should Reward UK remain uncooperative, Harim can report the matter to the trading standards or file a claim in the small claim courts. To conclude, Reward UK has breached several statutory obligations under the Sale of Good Act 1979, and Harim is fully within her rights to seek appropriate legal remedies. At the last, I will suggest that there should be another remedy called rescission. where parties come back to their pre-contractual position. This essentially means that the contract is treated as if it never existed. I thank you all. This was all about my presentation.